All right. Well, we're at 6 o'clock, so we'll get started. And as people join us, they can just sign in. So welcome to our webinar. I'm Suzanne Sayward, a partner at the Dedham, Massachusetts law firm of Samuel, Sayward & Baler. And I'm here today with my partner, Maria Baylor. And this is our Smart Counsel webinar series. For those of you who have hung around with us for a while, you know that we used to do these in our office where we had snacks and wine and all sorts of goodies. But now you're on your own with the snacks and the wine. But perhaps maybe later this year, we can get back to in-office webinars. So today we're going to do sort of a basics program, but we're going to try to present this in a way that makes it a little bit interactive and we hope fun and interesting for everyone who is attending. And what we're going to do is post a question which you will be able to answer true or false. All the questions are true or false. Your answers will be anonymous. And then Maria and I will chat about the question and we'll see who got how many answered correctly. And we'll all learn a little bit about estate planning and elder law. Okay, so let's get started. So let's see. You can tell we're not completely webinar savvy as I am now searching for my poll here. All right, well, let's see. All right, I think I got it. All right, good. Sorry for that delay. Here's our first question.
So if you give,
go ahead, Maria.
If you give your child a one-time gift of $100,000, you will not owe any gift tax. True or false?
Click away. All right, well, we've got everybody just about answered. And we'll share the results. Can everybody see that?
So 67% of you said that was false. And the answer is true. I would say 99% of the time, the answer to that question is going to be true. If you give your child a one-time gift of $100,000, you will not owe any gift tax. The reason for that is that the federal gift tax laws, which govern the answer to this question, work this way. You can give any person in the world a gift of $15,000 a year without paying any gift tax and without having to file a gift tax return. That's called an annual exclusion gift. They used to be $10,000 a year. That's kind of the number that people think about when you think about annual exclusion gifts, but they get adjusted for inflation. So by now it's $15,000 a year you can give without any strings attached. If you give a gift of more than $15,000 in any one year to a particular person, the amount of that gift over $15,000 is called an excess gift or a taxable gift. And the amount of that excess or taxable gift reduces the amount you can give over your lifetime without paying any gift tax. Right now, that amount is $11.7 million per person. So if I give my child $100,000 this year, $15,000 of that gift will be an annual exclusion gift, and the remaining $85,000 is going to reduce my lifetime gift tax exemption of $11.7 million. So 11.7 million minus 85,000 is $11,615,000. Is that right?
Well done.
Thank you.
Math off the top of your head.
So that's what I have remaining in my lifetime gift tax exemption. So even though if you make an excess gift of $85,000 in this example, you are going to have to file a gift tax return next April and disclose to the IRS that you've made that excess gift and show the IRS I had $11.7 million of lifetime exemption. I used $85,000. Now I have $11,615,000 left. That's all you have to do. There's going to be no gift tax owed until you've given away your entire $11.7 million lifetime exemption in gifts. That's why I said it's mostly true, because if I was very wealthy and I had given already $11.7 million of taxable excess gifts away during my lifetime, and then this year I decided to give another $100,000, I would have to pay gift tax on that $85,000. So for most of us who don't have $11.7 million to give away, we're not going to pay any gift tax if we're giving gifts, even if they're over and above the annual exclusion amount, although we may have to file a gift tax return.
So one thing to know about this is you may be familiar with the proposed legislation that was that's pending in Congress or is being discussed. The bill is called For the 99.5%. And it proposes lots of changes to the estate and gift tax rules, including reducing the amount of that $11.7 million gift tax freebie to $1 million and reducing the estate tax exemption to $3.5 million. It also messes with the annual exclusion amounts. So things could be very different, but that's for another day. Okay, so now we're on to our next poll. I'm going to be faster this time, I think. Let's see. Okay, question number 2. Only assets valued at more than $5 million only estates valued at more than $5 million are subject to estate tax. True or false? Okay, so we've got everybody in on this and sharing the results. So 70% said false and 30% said true. And in this case, the false answers are correct. So for Massachusetts purposes, we have a $1 million exemption for estate tax purposes, unlike the $11.7 million that Maria referenced in the last question that we have for federal estate tax purposes. So while most people don't have to pay any federal estate tax, many people who reside in Massachusetts may need to pay an estate tax because, let's face it, $1 million ain't what it used to be. So you own a home, you have an IRA, maybe you've got some life insurance, some money in the bank, and it's not too soon before you're up over $1 million. So the answer to that is false, because yes, if you're over $1 million, you may still need to pay estate tax.
I was just grabbing my estate tax chart here. So if you have a $5 million estate in Massachusetts and you pass away, the Massachusetts estate tax on that amount would be around $400,000. So that's the amount of tax you would have to pay to Massachusetts. Right now, you wouldn't have to pay anything to the IRS because you're under that $11.7 million. If the tax changes that they're proposing take effect, that Sue was mentioning, and we go back to a $3.5 million exemption, then the amounts over $3.5 million, so the $1.5 million excess in this example would be taxed at, I think 45% is the proposal.
45%. That's the proposal.
Yeah.
Right.
So.
Now, if you're a married couple, you each get $1 million, but in order to take advantage of that in Massachusetts, you have to do a little bit of planning. You don't get it automatically. So if that's your case and you haven't looked into this, you should do that because it will save your family about $100,000. Okay, on to question 3.
We should mention, if you have questions, put them in the Q&A. You can type them into the Q&A box. If you click at the Q&A logo or little icon at the bottom of your screen, you can see that, and then we can see your questions, and we'll either answer them as you type them in, or we'll answer them at the end, depending on whether we see them in time or not. Question number 3 is, putting the house in their children's names is advisable for most people over the age of 70.
Okay, that was a pretty quick response there. All right, so here we go on that. 75% said false and 25% said true.
We can't see the results.
Oh, you can. Sorry about that.
Yeah,
there
that's
we
okay.
go. All right.
Okay.
Okay. So 75% said false, 25% said true.
So in this case, again, generally the answer is false. You don't want to put your house into your children's name, no matter what age you are, really, unless there are really special circumstances that apply to your situation. The reason for that is, if you give your house away, no matter who you give it to, you're putting yourself at risk because you don't own the property anymore. And whoever owns the property can sell it, can rent it to somebody else, can mortgage it and stop paying the mortgage, and the bank will foreclose. So there are things your children could do with that property that would affect your ability to continue to live there. And we're assuming in this example that this is your house and you're going to want to continue to live there even after you give it away. So transferring the house into their names puts you a little bit at risk. Also, your children could, through no fault of their own, have creditors that are coming after them because they've hit someone driving through a crosswalk or stop paying their credit card bills, and liens could go on the property. If the creditors get a judgment against the child, they could try and force a sale of the property to pay themselves. Your child could get divorced, and the house could become an asset that's subject to division in the divorce, and before you know it, your ex-daughter-in-law is owning half the house that you're living in. We could go on, but this is not a good situation. So the better way to do it, and there are reasons you might want to transfer an interest in your house to your children, the better way to do it, it would be to put the house in a trust or to reserve what we call a life estate interest in the property, where you have the legal right to live in that house no matter what craziness is going on with your children or the person who might own what we call the remainder interest. So there are ways to do this, and sometimes it makes sense to do this to protect the house if we're doing long-term care planning or even tax planning, but generally wholesale transferring your house to your children is not a good idea.
I think the takeaway from this is, you want to be very thoughtful and understand the consequences of making these types of transfers. There may be circumstances where this makes sense. You're a single person, you have one child, and she's the perfect child, and maybe she lives with you, or for whatever reason it makes sense. You know, there are circumstances where this can be a good idea, but as a general rule, no. Once you're 70, you shouldn't run out and put your house into your kids' names. All right. All right, question number 4. A person who has a taxable estate can create an irrevocable trust to reduce estate taxes.
You can't see the questions.
All right. You know, I gotta keep my mouse down here. It doesn't seem to move around. Okay. A person who has a taxable estate can create an irrevocable trust to reduce estate taxes. True or false? Wow, that was fast. 100% of people said true. And yeah, this is true. You know, there's lots of different types of trusts. I often tell people, you know, talking about a trust is like talking about, I have a car. Well, yeah, you might have a Maserati or you might have a 1990 Ford. You know, they're very different vehicles. So there's lots of different types of trusts out there as well. And there are irrevocable trusts that you can use to reduce estate taxes. Those often involve giving up access to the asset. So for example, say I have a $20 million estate and I want to reduce my estate before the laws change, and I decide I'm going to give $10 million to my kids, but I don't really want them to have that $10 million in their hands. So I would create an irrevocable trust of which my children would be the beneficiaries, and there would be restrictions on their access to that money. And I would name somebody who would be the trustee who would manage those assets. The assets that I'm giving to them in this trust are protected from their creditors, but they're out of my estate. And now, at least under the current laws, that $10 million is out of my estate, and the appreciation on it will not be part of my estate either. So say it's stock and I live for another 20 years, and now when I die, those trust assets are worth 30 million. Well, that's all out of my estate. Now, remember, when I made that $10 million gift, I did use up $10 million of my 11.7 million freebie. So now when I die and I've got that $10 million that I didn't give away, I've only got $1.7 million of freebie left. So my estate is still going to have to pay some estate taxes, but I've reduced it significantly.
And the reason you give away large gifts like that for estate tax planning is to get the future appreciation of the asset out of your estate. And so it works well with things that are going to appreciate, like real estate or stock or
a business.
Right, a business, exactly. The trick is you can't have any strings. You can't keep the income. You can't use the house. You can't go on vacation to your vacation home on the Cape without paying rent, you know, if you've given it away, unless you don't want to, unless, or I should say, that asset will still be part of your estate for estate tax purposes if you keep using it, right? You can't have your cake and eat it too. So you got to really want to give it away.
You've got to give it up.
Yeah.
Another very common type of irrevocable trust that people use for estate tax planning is an irrevocable life insurance trust. And that's a trust that owns or purchases a life insurance policy on somebody, say on my life, this life insurance trust purchases a policy on my life for $5 million, so that those proceeds are not part of my taxable estate when I die, and my children basically have this tax-free pot of money over there to pay the tax that will be due in my estate. So that really isn't reducing the value of my estate. It's just providing them with cheaper money with which to pay the tax. You know, we haven't, in the olden days, before 2010, when the federal estate tax was a much more of an issue, we talked about using irrevocable life insurance trusts quite a bit. They were a very common planning tool. not so much in the past, 10 or 11 years where we have had these very large exemptions because they just have not been needed, but that might change. So we'll see. We'll see. Okay. All right, on to question 5. Is this you, Maria, or me?
Oh, sorry, I was busy looking at the Q&A. It's me. A trust is only appropriate for individuals who have more than $500,000. True or false?
And we've got 100% answering and 100% saying false. And that is correct.
These people, these attendees must all be our clients because they're so smart and they've learned over the years all of the lessons we've taught them. So that is correct. It's false. A trust is appropriate for anybody who has assets that would otherwise go through probate at their death, and you want to avoid probate and the time and the expense of that. Or if you want assets managed for beneficiaries after your lifetime, minor children who are not minor but may have some issues managing money responsibly, disabled beneficiaries, children that may have creditor issues or that you might be concerned about divorce, anybody you want to protect assets for. So there's a wide range of reasons why you would create a trust, and you can put any amount of money in a trust. If you have $1,000, I don't know, bank account that you want protected, go for it. You can create a trust to own that. So it's not just for the wealthy. That's absolutely true.
So I think one of the takeaways here is, everybody's situation is unique. And whether or not a trust is right for you depends upon your situation. It's not driven by the value of what you have, but it is what's important to you. What are your goals? What's the nature of your assets? So lots of factors. So each person really needs to consider this for themselves. Okay. All right, number 6. Probate is not necessary if you have a will. Holy moly, they're right on the button, Maria. It's like Jeopardy. All right, so we've got 100% answering there, 100% false, and that is absolutely correct. So as Maria said, you are a very smart group because there are very many people who think, oh, I've got a will, I don't need to worry about probate. But whether or not you have a will has no bearing on whether or not your assets need to be probated, because probate is really the court process of changing the title on an asset when someone passes away. So if you die owning an asset, a bank account, a piece of real estate, anything that's in your individual name, so it's not jointly held, it's not in a trust, and if it doesn't have a named beneficiary, then it has to go to probate. Because otherwise, how does that institution know, that bank or that brokerage account or that brokerage firm know who's entitled to get access to it? So, if I have a bank account, it's just in my name alone, Sue Sayward, and I die, my family goes down to the bank and says, oh, she's dead, give us all the money. They would say, no, we don't know who this rightfully belongs to. You need to bring us the paperwork from the court that proves who the rightful owner of this is. And when you die owning a probate asset, the rightful owner is the person who's appointed as the personal representative of your estate. That used to be called executor, but now it's called personal representative. So the court process is to file those pleadings, get what's now called letters of authority that appoint the personal representative, who now can go back to the bank and said, oh, here I am, I've got my official documentation. Now close out that account and open a new account in the name of personal representative of the estate of the decedent. So that's how that process works. And, we just want to say a little word here about the probate process. you know, probate has always been something to avoid. I mean, for years, we've talked with clients about doing their estate planning and avoiding probate as a goal. But COVID has not made probate any better. It's really a mess.
That's an understatement.
So it takes a long time to get anything out of the probate court. You know, they're even more understaffed than they used to be, and they only go in every other week, and the mail is not open for months on end, we hear. And of course, they're dealing with, you know, 17,000 more estates than normal. So it's all bad. And, you know, setting up your estate to avoid probate is just more important than ever.
We should mention that a will allows you to control the probate process in the sense that you can name who the personal representative is. You can name who's going to get the assets in your probate estate. If you die without a will and you have assets that need to go through probate, then the state law would control who receives the assets, and the personal representative of the estate. There is a kind of a priority established by law, but in general, whoever applies for the job, you know, will be evaluated by the court depending on this order of priority and appointed. So a will allows you to pick the people who are going to do the job and also where the money goes, and not rely on the state law to do that for you.
All right, good.
We have some questions, but let's answer them at the end. I think that's the best way to do it, so we can keep on plugging. And then those who want to wait for the answers, we have some good questions, so stick around.
Okay.
But
Good. All right. So, well, we're on question 7, so we're doing a good job here, Maria.
Yep. So question 7, can you put that up, Sue?
Yep. Here we go.
Your trust should be the beneficiary of your IRA only if you have minor children. True or false?
Oh. All right, we've got just about everybody in there. All right, we've got 73% say false and 27% say true.
Okay, so I would say the answer to this is false. If you have minor children, it's definitely true that your trust should be the beneficiary of your IRA. You don't want retirement benefits being paid to minor children. In, I think, practically all cases, the financial institution is going to require a guardian to be appointed for those minor children to get access to those funds, even if you have a surviving spouse who's the parent of those children. They would still need to be appointed by the court to have legal authority to access those funds on behalf of the minor. So that's again, involvement of the probate court, which we've learned in the last question we want to avoid, right? So, but there are other reasons to name a trust as the recipient or the beneficiary of retirement accounts at your death. Going back to what we talked about in terms of why you create a trust in the first place, if you have any beneficiary of whatever age who needs assets managed for them, whether it's minor children, spendthrift children, irresponsible children, people with substance abuse, a disabled beneficiary, children with creditor issues, all of those people would benefit from having those types of assets held in a trust for their benefit, rather than being the direct beneficiary of those accounts. Once you die and the retirement accounts pay to any beneficiary directly, those are their assets, and they can be spent by the beneficiary as they wish. The beneficiary's creditors can reach those assets. So if you have concerns about managing assets or protecting assets for beneficiaries, a trust is a better recipient of those retirement accounts.
So just to add to that, so last year at the beginning of 2020, before the pandemic struck even, we were struck with the Secure Act, which is a federal law that changes the way that beneficiaries can take money out of an inherited IRA. Now, this doesn't apply to a surviving spouse. Those rules have stayed the same, which basically is if your spouse dies and you are the beneficiary of his or her IRA or 401k, the surviving spouse rolls that over into his or her name and it becomes that person's retirement account, and they can take withdrawals based on their life expectancy using that chart. But the rules are now different if an IRA or other retirement account is inherited by a non-spouse beneficiary. Under the old rules, it was terrific. If you inherited an IRA, you had the option to take withdrawals of that IRA over your life expectancy. You never had the option to say, I'm not going to take anything till I'm 70 and a half, like you would with your own IRA. When you inherited an IRA, you always had to start taking it out right away, or you were limited to having to take it out over a shorter period of time. So the smartest thing to do was to say, yeah, I'm going to take it over my life expectancy. And so say the parent passes away and the child is age 53, and the IRS assumes everybody lives to age 83. So there's a 30-year life expectancy, and that child could take that out 1/30th, 1/29th, 1/28th, and so on, and only have to pay the tax on what the child withdrew. So 1/30th in the first year, a very small amount. And in the meantime, the rest of what's in that IRA continues to grow tax-free. It was a great benefit, but it's gone. So now, as of January 1st, 2020,
wants its tax money quicker.
That's right. That's right. So this is one of the ways that Congress was paying for the tax cuts to the rich people that happened in 2018. So now, for anybody who dies after January 1st, 2020 and leaves an IRA or a 401k to a non-spouse beneficiary, typically a child, that beneficiary has to take all of the money out of that IRA by the end of the 10th year following the death of the owner and pay the tax on that. So you can see that makes a huge difference. If someone inherits $1 million IRA and they could take it out over 30 years and pay the tax versus having to take it out over 10 years, even if they're not in a big bracket, a high tax bracket, they might become in a high tax bracket once they're having to take $100,000 of taxable income. So, this is even trickier when we talk about trusts because of tax rates on trusts. And I don't want to send everyone into a coma because there's still a couple of more questions to answer, but it is complicated. And if you have this situation where you have a trust and retirement assets and you want to explore, okay, what's the best thing for me to do? All right, so
Question
now
8.
we're on to question 8. Okay, question 8. You can give your assets to your spouse and it will not result in a 5-year penalty for long-term Medicaid eligibility purposes. True or false? All right, so on this, we had 89% said false and 11% said true. All right, you guys, we finally tricked you. So on this one, the answer is true. And this, of course, relates to people who are going to apply for Medicaid benefits, typically because one spouse has gone to a nursing home. And everybody's clearly familiar with the rule that says that you're not eligible for Medicaid benefits if you have given away any of your assets within 5 years preceding the filing of the application. However, this does not apply to transfers between spouses. You can transfer your assets, all your assets, to your spouse on Tuesday and go to the nursing home on Wednesday and apply for Medicaid benefits, and that transfer will not impact your eligibility. That's not as good as it sounds, because the reason they don't care if you transfer assets between spouses is that when one member of a married couple applies for Medicaid, long-term Medicaid benefits, they look at the assets of both spouses. So it doesn't matter in whose name those assets are. They will evaluate the eligibility based on all of those assets.
It doesn't matter for eligibility purposes who owns the assets, but we often do want to transfer assets into the name of the healthy spouse, the non-nursing home spouse, for other reasons, for planning reasons. You know, if, for example, if there's a house, let's say, that house can be owned by the non-nursing home spouse in their own name, and the ill spouse can still qualify for Medicaid. What we're trying to protect against is if that healthier spouse passes away unexpectedly before the nursing home spouse, we want to be able to direct those assets that the non-nursing home spouse owns in a different direction, right? If the house continued to be owned jointly by the spouses and the healthy spouse died first, the house would then be owned entirely by the spouse in the nursing home. And that would still be okay for Medicaid, but when that spouse died, Medicaid could file a claim against their estate and get repayment of the benefits paid to that spouse from the value of the house. Whereas if the healthier spouse owns it and her will says, at my death, the house goes to my kids or goes into a special type of trust for my spouse, we can potentially avoid the claim. So that's what we're trying to do by moving assets around. And that's true with other, cash or other types of assets as well. Question number 9.
All right.
So if your child's name is on your bank account as a joint owner, the account is vulnerable to your child's creditors, true or false? I seem to be getting all the questions where there are children with creditors.
Okay. So we had 92% of people thought that was true and 8% of people thought that was false.
Okay. So that is true. Good job, everybody. Any asset that anyone owns is vulnerable to their creditors, right? So if you have a bank account, it's vulnerable to your creditors. If you choose to make someone else a joint owner, like a child, you've essentially given them half that account, or even all the account if it's a bank account, because the child could go to the bank and withdraw all the money the next day. And so their creditors know that too. So if your child has a judgment against them and a creditor is looking for assets to attach and take to satisfy that judgment, and they see the child's name on that account, they can go after that account. So adding a child as a joint owner on an account for that reason is usually not a great idea. It's also not a great idea because when you pass away, that account will pass entirely into the child's ownership. And unless your will says that wasn't my intention, I want the child to share that with my other kids, that asset may not be distributed in the way you want your assets distributed at death. So even though it's convenient to do that, it's probably not a good idea. People do that because they want to make sure their child can pay their bills if something happened to them, if they got sick. And we typically explain to clients, it's not necessary to put your child's name on the account. Just have a power of attorney, a financial durable power of attorney that allows your child to pay your bills and do other things for you if you're not able to do it for yourself. And that child, using the power of attorney at the appropriate time, will be able to go to the bank and do what they need to do with that account, even if it's only in your individual name.
Or it could be in your trust. If you have a trust, then your account should be in the name of your trust. In terms of adding a child to a bank account, if you have, what you might call your operating account, your checking account, you don't keep a lot of money in there. It's sort of a money in, money out. A lot of times people will have one of their kids on there as a for the convenience sake, as Maria said. But certainly if you have larger accounts or investment, if you add your child as an investment account, you may find yourself as a joint owner, you may find yourself unable to get access to that account without your child's participation. I've had that situation with clients who've added a child to like a brokerage account or a mutual fund or something. So, just be careful about that. All right, so then we're almost at the end. We've got 2 more questions here. So question number 10. Oops. Number 10, there we go. Okay. If you are named as an agent for your brother on his power of attorney, you can use the power of attorney after his death to access his bank accounts to pay funeral expenses. True or false? Oh, interesting. So, oh, wait, somebody changed their mind. We had a 50-50 split, but it went to 45-55, or we had one person jump in. Okay, so we've got 55% say false and 45% say true. Okay, well, the false people are correct. A durable power of attorney, which Maria was talking about on the prior question, is a document that you use to designate someone called your attorney in fact, who can act for you during your lifetime. And it's used primarily for circumstances where somebody becomes incapacitated and they're not able to act for themselves, although most powers of attorney are not contingent upon that incapacity. But when someone passes away, the durable power of attorney ceases to have any legal effect. Now, having said that, I have to say that we have seen some funny things in our years where, the bank doesn't necessarily know what the law is. And we've seen people take a power of attorney to the bank. Oh, my brother passed away and I have the power of attorney. Let me close the account. And the bank lady saying, oh, that's a great idea. So, so yes, the answer is false, but sometimes it could be true.
And sometimes the bank doesn't know the person has passed away, and you go to the bank with your power of attorney and you conveniently don't tell them that the person's passed away and you want to use the power of attorney to access the account. It may be possible to do it. The question is it legal to do it? The answer is no. If somebody chose to, if you took money out of that account after death using a power of attorney, whoever the personal representative of the estate is would be able to get that money back from you because you did not lawfully take the money out. The power of attorney becomes void at death. You should not be acting under it or using it, unless you don't know the person is dead.
Right.
I think that's the exception to the rule. So.
Right. Oh, I forgot to share the results on this, but there we go. I did tell you what they were.
Okay.
All right. Last question.
If your spouse becomes incapacitated, you can act on his or her behalf because you are married, for example, to get access to their IRA or sell your jointly owned home. True or false?
Okay, so we've got 83% false and 17% true.
Okay, good job. This is a false. The answer is false. And unfortunately, just because you're married, you don't have the power you think you have. The 17% of you who answered true are not, it's not unusual. I have a lot of married couples who think they can do anything for their spouse, and probably they've spent their whole life doing everything for their spouse in some cases, and they think it can just continue if their spouse is incapacitated. But but the truth is you can't act on someone else's behalf without authority to do it. And just because you're married to that person doesn't give you any kind of legal authority. If you're a joint owner on an asset, like a bank account, you can get access to that. But things like real estate, even jointly owned real estate, cannot be sold or mortgaged without both parties participating and signing documents. So just because you're a married couple doesn't change that. And that's where powers of attorney are very important, so you can give your spouse the authority to be able to sell the house or mortgage the house or refinance or do things that might need to be done if you can't sign those documents yourself. I think the other example was a retirement account, right? So any other asset that's in the spouse's individual name, the IRA, maybe your spouse needs to take out minimum distributions and he's incapacitated. You would need legal authority to ask the custodian to make that distribution. So anything that's owned by a person in their individual name, no one would have the authority to give direction or take action on those assets without a power of attorney.
And although, you might think to yourself, well, that doesn't really make sense because we do this for each other all the time. And I'm the person that always deals with it. Remember, not all spouses are real fond of each other. So, you wouldn't necessarily want that marital status to give you legal rights. I have clients who separated 20 years ago. They never got divorced, but they live apart and whatnot. And certainly one of them would not want the other one to be able to make decisions or get access to assets just because they are still legally married. So you do need to have that legal document in place. And, it's a common part of every estate plan to have that and to appoint somebody who would be able to do those things for you if you couldn't, because without it, and we see this happen, somebody gets sick or takes a fall or has an accident and there isn't a power of attorney in place. Now you're back in the probate court seeking a guardianship and a conservatorship so that you can make decisions for your spouse. And it's not a good place to be. So, basic estate planning can make sure that you never have to be in that position.
And you don't have to name your spouse in your power of attorney. If your spouse is not well or your spouse doesn't have, isn't financially savvy and maybe you wouldn't want to give them the authority to act for you regarding financial matters, you could name a child, you can name some other trusted person to do those things for you. But you should just have somebody who's able to act for you in those circumstances. Okay, let's get to our questions.
Okay.
So the first question is, do you have to pay federal taxes for a $100,000 gift? So we talked about how you don't have to pay gift tax for the $100,000 gift unless you've given away your entire federal exemption amount before you make the gift. So this year that would be, you'd have to have given away $11.7 million and then make a taxable gift, in which case you'd pay gift tax at the rate of 40% this year.
If you have a spouse, your spouse can join in. So you've got between the two of you, whatever that number is, clearly Maria's the math person, 23,000 or whatever that total
23
is.
million.
23 million. Yeah, sorry.
11.7 times 2. Right?
There you go.
And change, right?
But the other thing too that's confusing about gifts, I think, when people are thinking about gifts is, they start to think about income taxes. Right. So when you're giving gifts to individuals, not to charities, but to people, or you're getting gifts from somebody, the person who makes the gift, the donor, that is not an income taxable, deductible event for them, rather. So if I give my child $20,000, that's not an income tax deduction for me. And when he receives that $20,000, that is not income taxable to him. It's just a gift. It's free money. So the only taxes you really worry about when you're making a gift are gift taxes. And depending upon the asset, you might want to think about capital gain taxes if you're going to be giving away an asset that's appreciated, like real estate or stock.
All right, so the next question is, what about revocable trusts that become irrevocable upon death? So that might have been more important in the context, but I think we were talking about revocable versus irrevocable, and irrevocable trusts can be used for tax planning reasons. So revocable trusts do become irrevocable when the donor or the creator of the trust dies, and the assets in that trust would then be distributed or held according to whatever instructions are in the trust. That's typically, and then estate tax, if it's a revocable trust, estate tax is paid on the value of those trust assets plus anything else that the grantor owned at the time of death. A revocable trust is part of the taxable estate. What else can we say about that transition?
Sometimes I think people they get nervous about the idea of an irrevocable trust. So they'll say, oh, well, this becomes irrevocable when I pass away. But that doesn't mean that people don't have access to the money in the trust. It just means that somebody else couldn't change the terms of it. So, you might set up tax savings trusts for your spouse, for each other. And when one spouse dies, that person's trust becomes irrevocable. The surviving spouse is typically the trustee of it and the beneficiary. But she can have distributions from it. She can change the ultimate beneficiary on the trust, usually by exercising what's called a power of appointment. I mean, these days we have something called decanting, which is not just for wine anymore, it's also for trusts. So there's lots of flexibility for irrevocable trusts. So don't think about that and say, oh, I would never want to do that because it's irrevocable.
Okay, next question. What is the tax structure on the irrevocable trust on the capital gain, dividend, interest, and rental income?
So that's a little, probably a higher level question, and it also relates a little bit to what I stopped going into when I talked about having the IRAs pay into a trust when somebody passes away. But currently, if you have an irrevocable trust, and let me do this by example. Say my dad passes away and he leaves assets in trust for me, and say there's $1 million in that trust, and that $1 million, now I'm going along, and it earns $100,000 of income, interest, dividends, maybe he had a rental property. So there's $100,000 of taxable income earned on the assets in that trust. Well, someone's going to pay the tax on that. And the person paying the tax is either me as the beneficiary or the trust, if the income stays in the trust and isn't distributed out to me. Under our current income tax structure, trusts like that are irrevocable have a compressed rate for income tax purposes. So while an individual doesn't reach that highest federal rate of, I think it's 37.6% right now, until they have something like close to $500,000 of income, an irrevocable trust reaches that highest federal income tax rate of 37.6% at about $13,000 of income in a year. So for the most part, you don't want to have the income remain in the trust and be taxed to the trust. You want it to come out to the beneficiaries and let the beneficiaries pay the tax.
And the same would be true of capital gain. If there's capital gain realized in a particular year, there is capital gain. Now the trust rules around capital gain are complicated. But
yeah, and the rate, they still have the same rate there, which can be beneficial, but then there's other rules that can create problems, like what's called the net investment tax surcharge comes into play. So yeah, you need to be careful. You want to look every year at the income in a trust if you're the beneficiary of an irrevocable trust. And Congress, in its wisdom, has recognized that you can't do this by December 31st of each year. So beneficiaries and trustees of irrevocable trusts have 65 days after the close of the tax year to figure out what the income was and decide that they're going to take more of it out and have it deemed to have been distributed to them in that prior tax year. So you get a little bit of a break there to figure that out.
Okay, next question. Can you name the beneficiary on real estate? Excellent question. Easy answer, no.
Not in Massachusetts. Some states do have pay on death beneficiary on deeds, but we do not.
Interesting. I didn't even know that.
Yeah.
So, okay. Let's see. Investment real estate and personal residence. Maybe that's part of the question above. It doesn't matter what kind of real estate it is, you cannot name a beneficiary in Massachusetts. If you put real estate in a trust, you can specify the beneficiary of the real estate, but not without a trust. The next question is, are there tax implications to trusts? Yeah, I think we talked about that in the last question. There are tax implications in the sense that if it's an irrevocable trust that you create and you're transferring assets into, there might be a gift that you're making to the trust, and those gift rules apply or work similarly to the gifts we were talking about before. And then there are income tax implications, like Sue was just talking about, depending on the income that's generated in the trust every year, whether it's distributed out or kept in, who's paying the tax and at what rate. So
now for revocable trusts, which is a very common type of trust that people do for their estate plan, there are no tax implications. If you set up a revocable trust and you put your investment account in there and your rental property in there and whatnot, it's all taxed to you. There's no separate tax ID number. So there's no tax ramifications for that.
Right. Okay. Let's see. Can a trust that became irrevocable at the death of one spouse be changed if the conditions for establishing the trust, for example, estate tax reduction, are no longer valid? Good question. The answer is yes. You can do that. How hard it is to do depends. But under our new trust code that took effect in 2012, there are provisions that allow for the modification of irrevocable trusts, particularly if circumstances have changed. I actually have a case I'm working on now, which is a pretty simple case that illustrates this. So a woman who's still alive created an irrevocable trust for long-term care planning purposes when she lived in Massachusetts. She put assets into this trust, and the trust allows the trustee, who is not her, to distribute income to her in the trustee's discretion. I don't really understand. That's a little bit of an unusual provision, but that's what the trust said. She moved to Ohio, and the Ohio attorney called the other day, and because the trustee is my client, I did not create this trust for his mother, but the Ohio attorney said, we need to modify this trust because she's in Ohio. She's not in a nursing home yet, but she might be headed there. She might need to apply for Medicaid. And in Ohio, if you have a trust with discretionary income, it's going to be countable as an asset when she applies for Medicaid. But if we modify the trust to make the income mandatory, so she has to get the income every year, that will allow the principal of the trust to be not countable. Interesting, right? This falls under the category of you learn something new every day, and I never knew that, but that's how it is in Ohio. So she wants us in Massachusetts to go to court, or if we can do it by agreement among the beneficiaries and the trustee, that this income provision will be changed from discretionary to mandatory. And we're in the process of looking at how we can do that. Sometimes you can modify a trust by agreement without the court's involvement, especially if the creator of the trust is still alive. Sometimes you need the court to agree that there was a change of circumstances or there was a reason why this should be changed. And courts don't do that lightly. You know, the courts are very respectful of the purpose of the trust and the intention of the person who created it, and only under, you know, specific circumstances will they agree to modify things. But we can request that, and in some cases it you know, it works the way it's supposed to.
And in fact, in Massachusetts, the courts are actually pretty amenable to reforming a trust for tax reasons. Like either because the tax laws, especially the estate tax laws, they change a lot. And if people don't update their trusts and then they die, then sometimes they don't work the way they intended them to work. And in that case, we go to court, we tell the court, listen, they tried to do this estate tax planning clearly, but you know, things changed and it's not working out. So can we get this reformed? And they're generally pretty amenable to saying, yes, that's fine.
So this person who's asking the question said the conditions for establishing the trust, which were estate tax reduction, are no longer valid. That might be a reason why a court would agree to reform the trust.
Yeah.
All right, next question. If my home is homesteaded and it's in my revocable trust, when I die, will it pass to the trust without probate? So if the house is already in the trust, that the home has been deeded to the trust, it's owned by the trust. When you die, that's not going to change. The house will avoid probate at your death because the trust owns it, you don't own it, so we don't need to transfer title from your name to the trust name at death. The homestead is an important thing. I'll let Sue tell you what that is, but it doesn't affect the trust or probate or any of that.
So homestead, the idea of homestead is really a possessory protection. You know, the government, again, in its wisdom, recognizes it's a bad idea for people to be forced out of their homes because they owe somebody money, because then they're going to live on the street and the state's going to have to take care of them, kind of thing. So the homestead law protects your right to live in the home. And if you do nothing, there's this automatic homestead of $125,000 in Massachusetts. But you can beef that up by filing with the Registry of Deeds where your home is located a declaration of homestead. And the protection then goes up to $500,000. But if you're a married couple and you're over 62, here's a killer, the state considers you're elderly then. So if you're over 62, then you're elderly, but the benefit to that is you get an additional $250,000 of homestead protection. So for a married couple who are both over the age of 62, you can have $1 million of homestead coverage on your home by filing an elderly homestead.
Yeah, but that when you pass away, the homestead does actually continue for the benefit of your spouse and any minor children you have, but it doesn't affect the probate situation. Okay, last question. Can the creator of the irrevocable trust, the grantor, take the income from the irrevocable trust?
So, you know, it depends on what the purpose of the trust is. So if you set up an irrevocable trust and you create the trust, you put your assets into it, and you keep the right to have the income from it, that's fine. But the assets in that trust are still fully taxable in your estate. You haven't removed them from your taxable estate because under the Internal Revenue Code, when you retain the right to the income, the asset continues to be deemed to belong to you. Now, this actually can work in your favor in some circumstances. For example, say you don't have a very large estate. You're not really worried about estate tax. It's under $1 million, but you are worried about protecting your home from a Medicaid lien if you have to go into a nursing home. So you have this house that you bought 40 years ago, you know, for short dollars, and now it's worth, you know, $600,000. But you only bought it for $100,000 or somewhere in there. So you've got this big gain on this house. If you continue to own the house when you pass away, at least under our current laws, your children will inherit that house with what's called a stepped up basis, meaning that the value for the basis for tax purposes will be equal to the value when you pass away. So again, back to my example, this $600,000 house, say it's my house, I continue to own it, I die. Now the tax basis is 600. So when my children sell the house for 600, they don't have to pay any capital gain tax. And since the value of my estate is under $1 million, there's no estate tax either. But contrast that with the, I give the house away or I put it into an irrevocable trust and it's not taxable in my estate anymore. Then there is no stepped up basis when I die because it's not part of my taxable estate. And so my kids then have that $100,000 basis or whatever my basis was. It's called carryover basis. And now when they sell the house, they're going to have to pay capital gain tax on that $500,000 gain. So it was much better in that circumstance for that to be taxable in my estate, so I can set it up in an irrevocable trust to protect it from having to be spent down on my long-term nursing home care or be subject to a lien, but still have it taxable in my estate. So, you know, again, it all depends upon what your intention is.
I lied. We have two more questions.
Okay.
One is, if real estate is owned by an LLC and one member dies, does their share have to go through probate? That's a good question. The answer is yes. You know,
I would go with it depends.
okay. Why don't you go ahead and take
So,
that?
because, you know, a lot of times, if it's a small LLC, like a family owned LLC or like two partners or just a single member LLC, then a lot of times we'll just transfer the membership interest over to the trust or the spouse or wherever it needs to go without going to probate. But if you're part of an LLC that's like a big LLC and you have a member interest that say it's a real estate investment trust or something like that, and you've invested in it and your interest is owned by you individually and you die, then probably that LLC manager is going to make you probate it.
It really goes to who's in control of transferring the title, right? If it's a big LLC, there's going to be an institution or somebody in charge of transferring that title, and they're going to want proof of where the title should go. If it's a family group, you know, they may say, oh, the will says it should go to his wife, Kathy. Okay, we'll transfer the interest to Kathy without the probate court saying you have authority to do it. But if there's controversy in the family or there are issues, then yeah, you're going to have to follow the rules and let the court appoint a personal rep who has authority and responsibility to transfer it according to the will. So
when we're doing planning for clients who have LLC interests, we do like to look at those operating agreements if there is an operating agreement, and see if we can either assign the interest to the LLC or even more simply do a pay on death designation for that member interest. So it's kind of like a life insurance policy or something. You designate a beneficiary and it just goes right to the trust or whoever the beneficiary is, so that it doesn't have to be probated. So, you know, that's something to look at. And if you're doing planning and you have your own LLC, then you can simply issue your member interest to yourself as trustee of your trust.
So the last question is back to the homestead. I think there was a little confusion on the numbers. So if a single homeowner is 62, does the amount of the homestead increase to $750? You lost me after you said 62 is elderly. I know, it's because it's disturbing to us that 62 is elderly, so we get all flustered about that. Yes,
and probably you did too. So you know what? No, you don't. If you're a single person, you don't get that extra benefit. And to me, I don't know whether this was like something like an unintended consequence in the law or whatever, but it is weird, because when you're a single person, you file a homestead, you get the 500 and that's it. But if you're a married person, you know, when one of you turns 62, you can get you can get to 750 at that point, and then the other one turns 62 and you can get to $1 million. So yeah, no, the law is if you're single, that's it. The 500 is the best you can do, and it doesn't seem fair, but that's what it is.
It's 500 per person if you think about it that way. So that's kind of how it makes sense.
Because, so what you're saying is that if you're a married couple and you have a traditional homestead, the under 62, you're really only getting $250 a person because you're splitting it?
Yes.
Okay.
Exactly.
All right, there you go.
Yeah. All right, so we're at the end of our excellent questions. I think before we leave, we just want to, we've made reference to the tax changes that are proposed, that are part of President Biden's infrastructure plan, but we just want to kind of give a plug for all of you to pay attention to that. You know, pay attention to the news. We're going to be doing a lot of education about that as the months go on, and as we learn more about these proposals and what's likely to happen. There are going to be major changes, most likely, that are going to affect all aspects of things: income tax, capital gain tax, estate tax, gift tax. So everything, a lot of the things we talked about today may no longer be true next year. So pay attention, stay informed, and, you know, we'll put articles out in our newsletter and on our website, and as soon as we know things, we'll share them. But it's a year that's going to see a lot of fluctuation in the tax laws.
So thank you, everybody, for attending. We really appreciate it. We hope you enjoyed it and that you learned a little something. And, you know, we'll probably do another webinar like this, another Smart Counsel webinar, before we can consider being back in the office. So stay tuned, and you'll see what comes across your email for our next webinar, probably sometime in July.
Sue, someone is asking if we've recorded this and if it will be available. So,
well, you saw how good I was with the technology. So
we are theoretically recording this.
Theoretically, I clicked the box that said record it. So yeah, we'll have it posted on our website if it is recorded.
And it'll be on YouTube, so there'll be a link to our YouTube page where you can watch the webinar. We also have other videos on our YouTube page, our shorter Smart Counsel for Lunch videos. So knock yourself out if you can't get enough of us. You know, go to YouTube and we're there in spades. So thanks, everybody. Great questions. Thanks for participating, and we'll see you again soon.